So far, I've emphasized that a contract is a consensual relationship created between the two parties. We've been always using two parties. Certainly, you can have two or more parties. In dealing with the enforcement of contracts, it is taken for granted that contractual rights and duties arise only between the parties and that the power of the enforcement only resides against each other. For instance, if Jean offers to sell Ben her watch and he accepts but later refuses to deliver it, if Ben decides to overlook the breach, his mother Edith, who is outraged by Jean's conduct, cannot successfully come in and sue her because Edith wasn't a party to the contract. We call this concept privity of contract. It's the relationship that exists between the promisor and the promisee of a contract. So third parties, the premise is that third parties have no rights to contracts to which they're not a party to. However, we're talking about contracts, and there are always exceptions to the rules. So there are certain situations where a third party, who's a non-party to a contract, may obtain the right to enforce a promise under the contract. And those three things: third-party beneficiaries, when there's an assignment of a contractual right or a delegation of a contractual duty. So a contract may create a right in a third party when the parties contract expressly or implicitly, where the parties to the contract expressly or implicitly agree at the time of making it that the performance of one of them will be rendered to or for the benefit of a person who is not a party to the contract, and that the non-party will have the right to enforce the commitment. That's our third-party beneficiaries. And then we have the assignment of contractual rights and the delegation of contractual duties, which is a transfer of rights and obligations by one of the parties at some time after the contract is executed. This does not involve any conferral of rights onto a non-party at the time of contracting. We already have a contract, and then one of the parties either assigns or delegates their responsibilities. So let's talk about assignments and delegations. These occur after the contract is made, when one of the parties transfers to another party a right or duty under the contract. Assignment and delegations are only possible once a contract has been made and those rights and obligations have come into existence. So this is after a contract has been made. So let's distinguish between the two of those. An assignment, where we got we're going to use two parties to a contract. We have different names. So when we were talking about offer and acceptance, we had the offerer and we had the offeree. Now once a contract is made, we have the obligee and the obligor. The obligee is the one that has the right to require the other to perform, and the obligor is the one who has the duty to perform. Okay? And when the obligee transfers their right to another, we call that an assignment. The one transferring the right, that's our original obligee, they now become the assignor. And the one who receives the assignment is the assignee. Our one who has the duty to perform still remains the obligor. So make sure you have all these, the termination, the names for all of these situations where you're in. So initially our obligee and our obligor were originally the offerer and the offeree, but now we have a contract and now they become the obligee and the obligor. And then once they have their contract, either one of them can, the obligee can assign their right and the obligor can delegate their duty. We'll get to delegation in a second. So keep these terms in mind when you're looking at contracts and what's happening. Okay, so let's look at some examples here. Mark obtains a car loan from Downtown Credit. Later, he receives a notice stating that Downtown Credit transferred, or assigned, its rights to receive payments on the loan to Car Loan Express and that he should make his payments to Car Loan Express. So let's talk about who's who here. Downtown Credit. Who's Downtown Credit? That's our assignor. He's the one who's transferring his right. And Car Loan Express becomes our assignee. And Mark still remains the obligor. So, who is Mark liable to? That is the question here. He's liable to Karl Express, who's the assignee. So he's not liable to the original party to the contract, who is Downtown Credit. Usually in the contracts there's provision. Normally in real life there's actually, when you make a contract of this type, there's normally a provision notifying the obligor that the obligee will and has the right to assign the loan, but no consent is actually required on the part of the obligor. Certainly if Mark said, no, I don't want you to assign my loan, he could not enter into the contract. But that's not usually the case, and we see it all the time in mortgage companies and so forth. So where's the contract here now? The contract was between Downtown Credit and Karl Express. That's our new contract. What happens to the original contract? It's extinguished by the assignment. So Mark's duty is to Credit Loan Express. Credit Loan Express can enforce it against Mark, but Downtown Credit cannot enforce it against Mark. Okay, before we get to this example, I want to go back to the... Before I go into this example that's here, I want to talk about another example. So I owe you $1,000. And who am I? I'm the obligor. Okay, you are the obligee. You don't have the time to collect from me, so you assign the debt to your friend Carmen, the right to receive the $1,000 from me next month. Maybe you need cash fast, you can't wait for the $1,000, so your agreement between Carmen is Carmen gives you $700 and you assign the debt to her. So who are you in this instance? You're the assignor, and Carmen becomes the assignee. You send me a letter stating that I have to pay Carmen next month, but I don't pay Carmen next month. Who can enforce the contract? Only Carmen. Who am I in this arrangement? I'm still the obligor, but the point is the role for the one who owes a duty hasn't changed. So in that instance, you do not have any rights to come and collect, only Carmen. So now to this example. Lender lent $1,000 to borrower. Shortly after borrower sold her car to the lender, that should say to lender, for $5,000. Lender took delivery of the car but didn't pay the $5,000. So lender assigns the $10,000 loan to Lucy. Borrower gets notice, so there's another typo, that should be gest. Gets, G-E-T-S, notice of the assignment but refuses to pay the loan because lender owes her $5,000. So do we have any issue here? So we have lender is lending the borrower $10,000. After that, the borrower sold her car to the lender for $5,000. Lender took the car but didn't pay the $5,000. Then lender assigns the $10,000 loan to Lucy, and borrower gets notice of that but refuses to pay the loan because lender still owes $5,000 for the car. Do we have a different kind of situation here? When the rights are assigned, the assignee can get no greater right against the obligor than the assignor, who was the original obligee, had. Okay? The assignee takes the rights subject to any conditions and defenses that the obligor may have against the assignor. So, do we have any issues here? If Lucy is going to enforce the $10,000 loan against borrower, can the borrower get that offset of $5,000? Yes. Yes, the borrower is entitled to have that offset because Lucy takes the assignment subject to any conditions or defenses that the borrower may have against the original lender, as long as the borrower knew of the assignment before the offset arose. So that's the key. And we're going to talk about notice in a little bit, the notice of assignments here and who has to do what. Okay, so most loans, or most, I shouldn't say that, most rights in contracts can be assigned. But there are times when the contract cannot be assigned. When the law prohibits assignment, The assignment changes the risk or duty of the obligor, and when a contract specifies that it cannot be assigned. So let's take these individually. The first one makes sense. If the law prohibits assignments, then there can be no assignment. Number 2, when an assignment changes the risk or duty of the obligor, that's the one that owes the performance. So this example, Alex owns a bakery and takes out insurance from ABC Insurance to cover fire, theft, and flooding. Alex assigns his policy over to Carmen, who owns a dress shop down the street. Okay? So is that a valid assignment? Who's the obligor in this situation? That's the assignee, the original obligor. The assignee is Alex. I'm sorry, the assignor is Alex. The assignee is now Carmen. So the insurance company remains the obligor. Does this arrangement change the risk or duty of the obligor? Could you do that? Not in this instance. The insurance company would clearly have a change in the risk or the duty. And insurance policies are given based on a company's evaluation of a particular risk, and they tailor it for that risk. So in this case, the insurance company's duty or risk would not allow for this assignment. And I'm pretty sure most insurance policies do not allow for the assignment of their insurance policies. The other next time, let's see, where contracts are prohibited. It's another time where we cannot have an assignment. However, there's exceptions to this rule. You cannot prohibit the assignment where the right is to receive money. A contract cannot prevent an assignment of the right to receive money. This exists to encourage the free flow of money and credit in business. So that makes sense. You cannot prohibit the assignment of rights in real estate. You sell me your property, but you want a provision that I cannot assign my rights to it to your neighbor. Maybe you don't like the neighbor. And this is contrary to public policy. It's a restraint against alienation. So that is prohibited. Assignment of negotiable instruments cannot be assigned. No restrictions on the prohibition of assignment of a negotiable instrument, such as a check or a line of credit. Again, the free flow of money is what's being protected here. And in sale of goods, we'll talk about this more when we talk about the sales component, but the sale of goods, the right to receive damages for a breach of contract or for a payment on account owed may be assigned, and it cannot be prohibited under contract. And we'll talk more about that under sales. So the next thing I want to jump to is the notice requirement. Notice of assignment. Okay, you are the obligor to a contract, and the obligee has assigned its rights to another. So therefore, you're obligated to the assignee. An assignment is effective once it's entered into between the assigner and the assignee, regardless of notice. That's when it becomes effective. There is no requirement that either assigner or assignee provide notice to the obligor. And usually it's up to the assignee to notify the obligor, but there is no law or no requirement that you receive notice of the assignment. So, example, I owe you $1,000 on a contractual obligation. You assign this debt to Maria. No one notifies me of this assignment, and I pay you $1,000. My first question is, was the assignment valid? Yes. It's once it's entered into. Do I still owe Maria? That is the question. No. My payment to you discharged the debt because I wasn't given notice of the assignment. What if I was given notice and I pay you anyway? The debt would not be discharged, and I would still owe Maria. Of course, you'd have to go and then sue. I'd have to go and sue you to get my $1,000 back. So notice is key, but it isn't certainly a requirement. So in the normal course, both in business, in real life business, both the assignor and the assignee provide notice, and usually the assignor is giving a obligor notice way in advance because they're already trying to make a contractual relationship, so they already know that they're entering into an agreement with an assignee. So you get a heads up way in advance in real life, and then you get a letter from the assignee. So delegations. Just like a party can transfer their rights through assignment, the obligor can also transfer their duties, and we call that transfer a delegation. A person who delegates her contractual duty is the obligor, and now the delegator of her duty. So we got more names here. The person who assumes the duty is called the delegate, not the delegatee. That's weird because that's the term that's used in the business law books that are not for law school. Law school books call it a delegate, and it is a delegate, D-E-L-E-G-A-T-E, not a D-E-L-E-G-A-T-E-E. So a delegate, one assuming the duty is a delegate. The other person to the contract whose right to perform has been delegated is still called the obligee. So some rules relative to delegation. There's not a whole lot. There's no special form to create it. The delegator, the obligor, is not relieved from their duty. Very different than the assignment, where once your right is assigned, you're out of the picture as the assigner or the original obligee, and you're subject to greater restrictions. So duties are treated a little differently. It's not a transfer of a right, so it does not invoke the policy that protects a person's interest in dealing with her property as she desires. So it stands to reason that while a mere assignment of rights will often make little difference in the other party's contractual expectations, the delegation of a duty is likely to have some sort of impact on the person who has the right of your performance. So it's subject to greater restrictions. So let's talk about some examples. Where is my example? Actually, I'll tell you what cannot be delegated, then we'll talk about the examples. So duties that are personal in nature. If the delegation will materially vary any expectation, and if a contract prohibits the delegation. So this is when you cannot delegate. So we'll talk about a bunch of examples here. Sue contracts with Karl to pick up some heavy construction machinery. Sue delegates this duty to Frank, who is in the business of delivering heavy machinery. So, who is Sue? Sue's our obligor. And Frank is the one. So Sue delegates this duty to Frank, so he's now the delegate. And Karl is the one who has the right. Okay? So, is this a valid delegation? Sue contracts with Karl to pick up some heavy construction machinery. Sue delegates this duty to Frank, who is in the business of delivering heavy machinery. Is this a valid delegation? Yes, it is. Why would it be? Why would it be? The reason why this is a valid delegation is the performance required is of a routine, it's non-personal in nature, and does not change Karl's expectation under the contract, right? There's nothing Karl needs or nothing special here. But let's talk about a couple other ones here. You enter into a contract with me to paint your house. You hire me based on reviews and my skill. You pay me $5,000, and then I delegate the duty to my 16-year-old neighbor. Is there a problem with that? Yes, there's a problem with that because there is something of personal nature here. The delegation will vary materially from what you expected because you hired me because of my skill and my reviews, and then I pawn it off on my 16-year-old neighbor. So no, that would not be a valid delegation. I agree to paint your shed because you hate painting. I get sick and I need an operation, but I delegate my duty to Tom to paint. Is that an okay delegation? Probably it would be. There's no special requirements here. You just needed your shed painted because you hate painting the shed. But if Tom doesn't paint, am I still obligated to paint the shed? Yes, I am. So I still have a duty even though I delegated it. Now, where's my other thing here? Now, can Frank, in this example here, Sue contracts with Karl to pick up some heavy duty construction machinery. Sue delegates this duty to Frank, who is in the business of delivering heavy machinery. Can Karl, if Frank doesn't perform, who's responsible? Okay, Sue is responsible as the original obligor. But does Karl have any recourse against Frank? Consider this example. Leo contracts to build Donna a house according to Donna's blueprint. Leo becomes seriously ill and contracts to have Hal build the house for Donna. Hal fails to build the house. Can Donna sue Leo? Yes. Can Donna sue Hal? Yes, and so could Karl in the other example. If a delegate has made a promise of performance that will directly benefit the obligee, there is an assumption of duty. So the breach of that duty makes the delegate liable to the obligee. So, yes, Hal could be sued here by Donna, and Karl can sue Frank in the example above. So you'd have options. Donna can sue both Leo and Hal, or can just sue Leo. So if an obligee has the right to sue either, in this case, Leo or Hal, is there ever a time where they can refuse a delegation? Leo contracts to build Donna a house according to Donna's blueprint. Leo becomes seriously ill and contracts to have Hal build the house for Donna. Hal fails to build the house. But let's forget about Hal failing to build the house. Can Donna refuse to have Hal build the house? Or how about the example prior to that, Sue, who contracts with Karl to pick up some heavy construction machinery? Sue delegates this duty to Frank, who is in the business of delivering heavy machinery. Can Karl refuse the delegation? No. An obligee must accept performance by a delegee because it is valid. Only under one of the exceptions can they refuse. So if there was a material alteration of the original duty, or I'm sorry, the original right that was going to be received by the obligor. Let's say this was the contract to paint a mural of, maybe Leo contracts to paint a mural for Donna on her wall inside her bedroom. And then he becomes sick and then he hires Hal. In that instance, if Leo is a famous painter who paints murals and Hal is his student, that is going to be something that Donna can object to under one of the terms. But if it's of something that's a non-personal nature and it's routine, then it's going to be a valid delegation, and the original obligee cannot refuse the delegation. So we move on to third-party beneficiaries. The parties to a contract can intend at the time they make the agreement that the contract performance directly benefits a third party. We can totally do that. So one who is not, we call a third-party beneficiary, one who is not a party to a contract, but for whose benefit a promise is made in the contract. So I can contract with you to mow my mother's lawn at her house for $50. My mom's the beneficiary of that contract, and she may have some legal rights, meaning that she can sue, but that's going to depend on whether or not she's considered an intended beneficiary or an incidental beneficiary. So we're going to talk about the difference between those two. So our intended beneficiary, they're a third party for whose benefit a promise is made in a contract. And these folks have rights. They can sue for breach of contract, basically, in the end. We have two types of intended beneficiaries. We have creditor and donee types. A creditor beneficiary benefits from a contract in which one party promises, that's our promisor, another party, a promisee, to pay the debt of the promisee owed to a third party. We see it, so it's a creditor beneficiary. We see that in a cosigner relationship. And in a donee beneficiary situation, they're an intended beneficiary. It's a contract that is made for the express purpose of giving a gift to a third party. We see that with life insurance, usually insurance policy type situations. So how do we determine who is an intended beneficiary, or how do we determine when their rights become in effect? So what are their rights? Well, we don't know yet until we see the contract, but their rights, before they can articulate or want to sue, their rights have to be what we call vested. It's a condition in which the rights have taken effect and cannot be taken away. A life insurance policy, let's take that example that we just talked about. Contracting party must die before the third party has any rights to the payment, right? Up until the rights are vested, or in that case, the contracting party dies, the promisor and the promisee, they can modify or do away with the contract without the consent of the third party. So when do the third party rights invest? We have a number of situations when they invest. When the conditions for vesting are satisfied in the life insurance policy, when the person dies. Or the third party demonstrates some manifestation of assent or consents to being a party, or yeah, I agree. My mom gonna mow my lawn for my mom. My mom says yes, I accept, and actually expresses their consent. When the third party materially alters his or her position and detrimental reliance on the contract, there's that promissory estoppel again. So in the example above, you don't mow my mother's lawn. Can she sue? And the question you got to ask is, was the contract vested? We'll see the list before. Conditions are satisfied. Well, we don't really have a condition that needs to be satisfied. You promise to mow the lawn, and I pay you $50. What if we have number two? What if she says, yes, I agree to you mowing my lawn, and then you don't mow the lawn, then she can sue you. We don't really have a material alters position situation here, but if we didn't have a number two, if she didn't consent, she may not have had her rights vested just yet. But what if you started mowing? What if you began mowing already? Is the condition satisfied? In that instance, it would be. So she might be able to sue you in that case, or she should be able to sue you in that case. So let me ask you this. What if the contracting parties expressly state in the contract that they reserve the right to modify or cancel the contract at any time? If I'm paying a premium for life insurance, but I stop paying, what happens? The insurance company stops the policy. And it's regardless of the third party beneficiary. So the rights of the third party are subject to changes despite any of their reliance. Oh, if somebody knows they're a beneficiary on a life insurance policy, too bad, so sad when it gets canceled because of non-payment. What if I'm supposed to pay you $50 ahead of time to mow my mother's lawn? and I don't pay you. Well, then if you don't mow the lawn, my mother can't sue you. Okay? How about this example? Wilkin owes Riviera $2,000. Howie promises Wilkin to pay Riviera the $2,000 in return for Wilkin's promise to give Howie's children guitar lessons. Is Riviera an intended beneficiary to the Howie-Wilkin contract? No, she is not. She is not intended. She doesn't meet the conditions above, and what she's probably going to be considered is what we're going to talk about next. An incidental beneficiary, a third party who incidentally benefits from a contract, but, that should say but, not bust, but has no rights in it and cannot sue if breached. So what distinguishes? What distinguishes between the incidental and intended beneficiary? Well, the court's going to use the reasonable person test. We're back to that objective standard. What would a reasonable person in the place of the third-party beneficiary believe? That the promisee intended to confer on the third party the right to bring suit to enforce the contract. So let's go back to Wilkin and Riviera. If you're looking as a reasonable person, you're looking at that contract, and you're Riviera, do you think you have the right to bring the suit? No. The suit is going to be between Wilkin and Howie. If Wilkin doesn't give guitar lessons or stops giving guitar lessons to Howie's children, and Howie doesn't pay, that's between those two. So that's the difference between an intended beneficiary and an incidental beneficiary. An intended beneficiary is going to be allowed to sue. They cannot sue until their rights are vested, which means the condition takes effect, which gives them the right to sue. An incidental beneficiary has no rights to sue whatsoever. They may receive a benefit to a contract between two people, i.e. in Riviera's case, you might get her $2,000 finally, but Wilkin has to give Howie's children guitar lessons. So make sure you review the 3 conditions on when the right's invested. You don't need all 3. It's either a 1, 2, or a 3 to determine which one is which, and you're going to look using the objective standard or the reasonable person.